I have turned down a lot of cases where I said, somebody will call you on Friday and say, we need an expert report by next Thursday. And you say, well, how big is the record? Which is something I didn't know anything about when I started.
Yeah.
Well, they'll say, there's 21 depositions.
During this season, I have interviewed quite a few expert witnesses, and most of them, when they are sharing about their introduction to the world of expert witnesses, they're like, "Oh, the first time I was asked to be an expert witness, I didn't even know what an expert witness is." Now, since you were a lawyer, so that was not the case with you. I'm sure you were like,
I knew what an expert witness was.
mm-hmm.
I had no idea the nuts and bolts of doing it.
Hello and welcome to a new episode of On the Stand with Ashish Arun. Today, I'm honored to welcome Richard Leisner, a highly regarded expert witness in complex business litigation and professional malpractice matters. With over 50 years of experience, Mr. Leissner has shaped the landscape of corporate law through his work with public and private companies across all stages of growth, from IPOs and mergers to high-stakes regulatory compliance and governance. A thought leader in securities law, Mr. Leissner has been recognized by Tampa Magazine on its top lawyers list and is a life member of the American Law Institute and a fellow of the American Bar Foundation. Known for his exceptional clarity and precision in translating complex financial and legal principles, he has become a sought-after expert witness nationwide. So it's a privilege to have Mr. Leissner on the podcast today to share his wealth of insights with us. Richard, welcome to the show.
Well, thank you, Ashish. I'm glad to be here. We're still recovering from the hurricane in Florida, broadcasting from my home studio, which isn't as cute as yours.
But it's real, and that is what we would love people to see. So let's start on that note right from the beginning. And as I understand, you started as a transactional lawyer and then you transitioned into expert witnessing. So can you take us back and talk about how the shift happened?
Sure. When I was a young lawyer out of law school, I started with a Wall Street firm and was there several years while my wife was getting her MBA. And then we moved to Tampa, where we've been ever since. But I'm doing the same sort of deals I did as a young lawyer, starting in I'll say quietly, the 1970s, and had a full plate of transactional experience. And one day, whether I was in a lull between deals, and I got a phone call from a colleague of mine, a retired senior SEC official, and she said, would you like to be an expert witness in Spokane, Washington? And I said yes. And the case was very interesting, and got involved in it, and I enjoyed it, and started to do more of it, and then actually, after a while, started to promote it as the mainstay of my practice.
Wow. So during this season, I have interviewed quite a few expert witnesses, and most of them, they're like, "Oh, the first time I was asked to be an expert witness, I didn't even know what an expert witness is." Now, since you were a lawyer, so that was not the case with you. I'm sure you were like,
I knew what an expert witness was.
mm-hmm.
I had no idea the nuts and bolts of doing it.
Yeah. So what was the biggest surprise when you actually when you went on to become an expert witness, and probably were you deposed on your first case, or the deposition happened came later?
The two first cases, which there was one that I'd done 10 years earlier, a criminal case that I don't even count, although it's on my CV. The first case in Spokane, I was deposed. The case went to trial. I testified. My testimony, the case was resolved in favor of the people who hired me, and then the case was appealed and upheld. So I went the full gamut, but I wasn't prepared. I wasn't prepared for what I didn't know what an expert report was.
Okay.
The people, I got to be honest, the people who hired me said, what do you think of these facts? And I told him, and he said, well, would you put it in writing? And I said, sure. And I did. I wrote him a letter, a 25-page letter, which looks today like something like an expert report. It doesn't hit every part of the expert Rule 26 in the federal rules, doesn't hit every part, but I would have given it a C plus on form. And it was it was the winning argument for the case on a technical issue of corporate finance law, that a national Big Four accounting firm had failed to raise. They didn't understand how the NASD worked.
Okay. So you also mentioned that you also learned some valuable lessons in courtroom conduct as an expert. Again, like this is again something new. So can you share a memorable moment that shaped your approach, like when you started as an expert, and then how did you change your approach with time?
Well, in this case, the first case in Spokane, and I
Yeah.
must tell you, if you've seen Back to the Future,
Mhm.
that the
Yeah.
courthouse, like that courthouse, it was a very traditional, staid, very conservative part of Washington State. So the local counsel, who was quite well known, the main Seattle firm, they were the big guns, but the local counsel uh, was a smoker.
Okay.
We left for a break, and he said, I got to get away from the courthouse. I can't let anybody see me smoking. And I had remembered investment bankers testified in that case, and they had on these very expensive tassel loafers. And when they got up on the witness stand, they crossed their legs, and you could see those, which I like those tassel loafers.
Uh-huh.
But I will now tell you, so you can see this. My wife gave me this watch. Let's see if we get
Hmm.
this here
Yeah.
for
Oh, that's nice.
our 25th anniversary a
Hmm.
long time ago, because we've been married 50 years. It's a Rolex.
Yeah.
This watch doesn't go to trial.
Yeah.
Uh, I'm pretty well. So I have a nice a nice leather banded watch that I wear, or
Hmm.
I might wear this one, the Fitbit, and
Hmm.
all of those things.
Yeah.
I fancy white shirt, white collars, and blue shirts, and cufflinks. You'll never see me doing that in
Hmm.
a court. I don't want them to remember what I wore. And some trial lawyers are known for flashy dressing. I don't know that any expert witness would be. So my objective is to have them remember my testimony. Um, the 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 other thing I guess that I learned, so that was a very good lesson, and I've
Hmm.
put it ever since. Um, Trial lawyers don't think about this, and I don't know. Some expert witnesses do, some don't. You shouldn't look like an unmade bed, but
Yeah.
you shouldn't look like you came out of uh, a, a new issue of GQ. Um, and that was very valuable. The other thing I had learned from trial lawyers is to be prepared. Whatever you think you're going to do, you need to be prepared to do something else.
Yeah.
I was in a case in federal court in New Orleans, and the everybody else in the case was on a first name basis with the judge and the judge's clerks,
Hmm.
including the opposing expert. Um, and so I'm up on this. It was an uphill battle. I'm on the stand, and they got my expert report, and we're going through the report. And the lawyer who's cross-examining me says, "Now, Mr. Leisner, didn't you say blah blah blah, something that was terrible for our side?"
Hmm.
And I paused and I said, "Can you show me where in my expert report that is?"
Yeah.
And the young lawyer fumbled through his papers, couldn't. He had not taken a sticky and put it on
Hmm.
the page of the report, and he couldn't find it. And so I think that derailed his testimony. I also remember once being in the Southern District of New York in the federal court, where they got the better of me asking a question, a loaded leading question that I didn't take long enough to answer. Walking home from the courthouse, I had a very good answer, but it
Yeah.
didn't at that time. So you need to be prepared for the unexpected, and I don't know exactly how you can prepare for that, but I found that to be pretty useful.
Mhm. So you have a very wide expertise. Like it's IPOs, their mergers, their corporate governance, and again, like, and these are things that litigators would not see unless a problem happens. So when you became an expert and now you're interacting with litigators, what are some of the common misconceptions that you found litigators or even juries had about corporate transactions when these disputes reached court?
Maybe they would say, this 55-page contract is 99% boilerplate.
Hmm.
And it might be 50% boilerplate, but the provisions are negotiated. Every deal is different. I think what litigators don't know is litigators have gone, as I said, an inch wide and a mile deep in the
Hmm.
last. But the thing that is right next to it, they might not know so well. And as an expert, you have to be prepared to say, look, I'm not sure you understand this. And I know I'm working on a malpractice defense case right now where it's a deal. And
Hmm.
like every deal, it starts with a letter of intent. And as I've said many times, no deal ever gets better after a letter of intent. It always gets worse in the contract. This was a point of contention, but you can't sue on the fact that I made a bad deal. But you can sue on the fact that your lawyers failed to tell you how bad it was. But I think, I don't know. We'll see with the next filing. I don't know whether I've succeeded in persuading my engaging counsel there was a difference between the deal got worse from the letter of intent to the executed agreement, and the executed agreement said what it said, but you didn't tell me how bad it was. And because the things that changed were in the letter of intent, they were good, and then they went not so good.
Hmm.
So I think you have to make sure that the litigators are listening to you.
Okay.
And I remember a case, you only think they're listening to you. Litigators are much busier than transactions lawyers. They have uh, uh, more plates that they're spinning on a stick than
Hmm.
most transactions lawyers might work on a handful of deals at the same time, sometimes only one deal at a time. Very hard work, lots of late hours, lots of pressure, but the litigator may have a half a dozen things that they're working on. And when you communicate with them, I have a partner like this. You only think you're talking to John. You have to grab him. He's a brilliant lawyer, but he'll be talking to you and you say, I don't think John got me on that. And litigators are like that. I had that happen in
Hmm.
a case where I had suggested they get something in discovery because it was very important. And they said, well, you never told us that. Discovery's closed. And I said, well, sure, look at that email. I said, oh, okay. And so I think that litigators are busier than have more distractions than transactions lawyers, I think.
Yeah.
Um, and
Hmm.
things I like about being an expert is you get to work at one case at a time, and I like that better.
Hmm. So no, but I mean, is that something that you do by choice, and you don't take another case till you are done with the current case, or like how is it like?
I'm laughing, Ashish. Uh, yeah, sometimes it's by choice. Here I am. uh, that's that's a discussion between Abraham and the Lord in the Old Testament. Here I am. Uh, but also, you're yes, I have
Mm-hmm.
turned down a lot of cases where I said, somebody will call you on Friday and say, we need an expert report by next Thursday. You say, well, how big is the record? Which is something I didn't know anything about when I started.
Yeah.
Well, they'll say, oh, there's 21 depositions. And we're on our fourth amended complaint. And can you do it for $5,000? That last part is a joke, but the you have to say to that person, "Oh, I can't help you.
Mm-hmm. Yeah.
It's going to take a couple of weeks to do this, to do it right, and there will be a cost." Um, it's been my experience. You will never find a prospective engaging counsel to say, I only hire these experts to plug a hole and give me a number, and I try to hire them at the last minute so that we don't run the fees up. No one will ever say that, but that happens a lot. And
Mm-hmm.
so I have, as I've gotten older, I have said, I'm a case I might have taken 20 years ago. I'll say, I'm not going to do that. And that's the kind of it's true in any endeavor. If you take on more than you can handle, you probably are not going to be happy about it, about the results. At least that's been my experience. I don't know well, you've seen more. I think experts make like everybody else. Experts make mistakes. I just
All kinds of.
The last article I've written about is kind of an interesting article posted on LinkedIn that had
Mm-hmm.
to do with a small fender bender at a traffic light, and the case dragged on for 3 years.
Wow.
The initial observation from one of the experts was, well, the guy got up from the automobile and he said, I've had bigger bumps and bruises at football practice. Okay, 3 years, discovery, $1.6 million. And the defense guys, and I'm not here to criticize anybody. I'm just here to read what was in the reporter. The defense guys had two experts.
Mm-hmm.
One was limited and the other was rejected. And it's not clear why. So Mr. Defendant was so disappointed. He did what any good defendant does. He sued his lawyer for malpractice. Because he thinks he shouldn't have had a $1.6 million verdict. And in that one, they didn't employ an expert witness because they said, we know exactly what our damages were, $1.6 million. And the court ruled, well, that's inadequate because you didn't say what a competent lawyer could have settled the case for. The only way to do that, to set the standard of care, is to have an expert. You didn't have an expert, so you lose. So poor Mr. Defendant lost with an expert. He lost without an expert, and I feel very badly for him. A gentleman I've never met, and in a different state, but it was reported, I guess, because it shows you what can go wrong with experts and without them as well.
So, how much of a factor do you think retaining the wrong expert or retaining an expert because you don't have enough time to do the due diligence, or you don't do due diligence anyway before you retain somebody? Like, how prevalent do you think that is? And what's your take on that?
Well, I know at least once or twice, I've been able, just as part of my job as a rebuttal expert,
Mm-hmm.
I tracked down Mr. Jones's prior publications. And he said some stuff in his publications that were different from what he said in his report about industry practices. I think I have not, and I did that opposition research.
Mm-hmm.
Guys who engaged me didn't do it, weren't hired to do it. They were happy to see it. I think that does not happen as much as it might, for the benefit of the party opposing that expert's testimony. And for the last 20 years, lawyers have used the Daubert standard as a way to try to get rid of what is pejoratively referred to as junk science. The areas where I testify in, there's no science there. It's more art than science. And so you would have to be able to testify. For example, I was in a case a couple of years ago, a marijuana case, where they were raising money to go out and have a major marijuana business, and with a private offering in securities. Now, I don't know anything about marijuana, but I know something about private offerings. So this particular case, one of the principals of the marijuana company had a brush with the law, and he had a conviction of the type of offense that under the securities laws, since 2016 anyway, that makes them ineligible to use that exemption. It's called being a bad actor, and it's a huge, long laundry list of offenses. Well, the lawyers in this case, they were marijuana lawyers, so we know how to do private offerings for marijuana, which apparently I guess they did, but they didn't check Mr. Jones, this one of the founders, for being a bad actor. And the irony of it, of course, was on that law firm's website during the middle of the litigation, there is posted an article by a junior lawyer at the firm talking about checking to see if you have a bad actor in your deal. And I think, and I could be wrong about this, I think the defense was, well, that article wasn't published until after we started this work. And it was a junior associate. And so I don't know if she knew that the firm was a defendant in a malpractice case. But in any event, I don't think much oppo research is undertaken, because it's not easy to do.
Oh yeah.
Which is apropos of what you guys are in.
Yeah, we have that is the primary business we are in, and I don't think anybody knows it better how difficult it is to do it. But because we've been doing this for a good 17 years now, we have developed some tricks, and we're able to pretty much cover more than a lawyer or a research librarian would be able to discover by themselves. But
they probably could do it themselves.
Oh yeah, they could. It would take like hours and hours of research and
they need the report by Thursday.
resources. Oh yeah.
So I think the reason that it doesn't happen is that reason, and I think some litigators think if I had an extra half an hour, I could do everything that we're hiring Leissner to do and do it better.
Yeah.
And heck, it may be true, but the enduring fact is that in a malpractice case, as we just talked, you have to have somebody come in and describe the standard of care. There was another case that I was involved in where a very, very big, I wrote about this as well, where the expert wasn't an expert at being an expert. And this was it was another private offering case where they failed to describe uncover a problem, and Mr. Jones, the expert from the fancy pants law firm that you would know, said, I would never have done it this way. And the judge said, well, that's swell, but that doesn't describe the standard of care, so your client loses. I've simplified it, but and so I wrote an article that said your expert may not be an expert about being an expert, and neither, this was something else I've observed, neither was the law firm that hired him. And I was in the one last war story. I was involved with in a compensation case for a very senior executive in the travel trade. and he had been paid a mountain of money to leave when private equity came in to fund the company because they threw him out.
Mm-hmm.
But it didn't satisfy him, so he sued on the edges and said, I was tricked. I need more money. So I was involved and getting ready for the testimony. The young partner, 15 years of experience, is getting ready, and he's planning for my direct to be an hour and a half.
Mm-hmm.
And I was very uneasy about it. And on the eve of, and this is a national law firm, okay, and on the eve of it, one of the partners comes in and we're passing the time of day, and he said, "Well, what does Jack have you planning to do?" And I told him with kind of a question, man. He said, "Well, that will never happen." And so at the last minute, we got everything down to 15 or 20 minutes. And
Yeah.
so even though the guy who hired me, knew the case backwards and forward, knew everything that there was to know, but what he didn't know is how much time you could have to do the testimony.
Mm-hmm.
So the sort of things. The other thing I was going to think of, because that was the same case where the trial was in Dade County, which is Miami, and in an old, old, old. Let me say one more time. Anybody who's in Dade County knows this old courthouse. Restrooms didn't work on every floor. There were posts in the middle of the courtroom, and the air conditioning wasn't great. And so when I get up to testify, you can see the jurors look like my law school class. The jurors are nodding off, and so your challenge is to grab their attention. And I remember when I started doing public speaking. What do they tell you? Imagine the audience in their underwear, but fix your eyes on somebody in the audience. And the people I stayed fixed on weren't sound asleep when we were done. And my guys got the result that they wanted. So those are things nobody can tell you to be ready for. That was also a trial in which they put up, this is long enough ago, they put up an overhead. No, maybe it might have been anyway, on the big screen. They put up a spreadsheet, and it was for a different year from the years in question.
Oh wow.
And it was a balance sheet with a lot of entries.
Mm-hmm.
And lucky me, I looked up at the top and I said, well, "This isn't the right one." And so that ended that when I pointed it out, and that ended that line of questioning. And, well, that's and usually you'll frequently have a paralegal who's in charge of all that stuff on the screens, and they are supposed to know heck, they may know the material better than the lawyer. But anyway, they put up the wrong screen, and lucky for me, I noticed it when I was talking to you about the Southern District of New York. I didn't notice, and they got me on cross. Um, by the way, the judge in this, who was a pretty new judge, wrote in her opinion, she said, "We paid no attention at all to Mr. Leisner's report." And then she went on to find in favor of the government, the SEC, in every respect that I'd put out in my report. So, so I felt good and bad. But that's you can never be. You never know what's going to happen in a trial. You hardly know what's going to happen in depositions. So I've taken you down the lane further than you wanted to go.
Yeah. So when you start a new case, what are some of the critical questions you think experts should ask engaging counsels in your line of work? Or maybe it can be specific to transaction law and SEC cases, or in general?
Ashish, the most important question
Mm-hmm.
that besides getting paid, the most important question is what does the case management order say about when I have to put in my report?
Mm-hmm.
And a lot of engaging counsel won't even send you the case management order. I didn't know what a case management order was when I started. That's the thing that says who does what when,
Yeah,
and
yeah.
what the deadlines are. I can remember a case where, and the case management order is usually agreed to pretty early. And since litigators live in today, they don't care about 10 days from now. They don't care about a year from now. And their practice doesn't allow them. It's not a slight on litigators. Anyway, so in this particular case, the expert report, the disclosure of experts, and the expert rebuttal report were all due on the same day. That's a good trick. If you can do that, if you can if you can if you can uh get anyway,
Mm-hmm.
don't look at that stuff at the start. Your counsel may or may not have, so
Yeah.
the most important thing, um, the next most important thing is to see what kind of support your engaging counsel is willing to provide you, willing or able.
Right.
Frequently said, no engaging counsel says, I wait to the last minute. I want it as cheap as possible. I want one-line answers. No one,
Mm-hmm.
no one will, even if they do that, they won't say it. So uh, the sorts of things that underlie careful and efficiently prepared expert reports and testimony are things like a detailed list of the players in a tabular format that you can
Okay.
read, not like 29 paragraphs about Mr. Jones was born in a log cabin, blah, blah, blah.
Mm-hmm.
Robert Jones, next column, CEO, ABC
Yeah.
Industries, and what did he say in that sort of a tabular format? Now, I've done those many, many times. Some lawyers do you the favor of doing it. And the same thing for timeline. If you have a complex deal, in order to
Yeah.
understand the deal, there needs to be a graphical timeline.
Right.
And so that's very important. I was in a toxic waste case
Okay.
for defending it, where the property had been polluted in the 19th century. And the way our EPA laws work, our environmental laws work, that toxic that taint stays with the property through every owner.
Mm-hmm.
So there were corporate reorganizations, there were purchases, there were sales, and actually the defendant in this case was one of the pieces of the Enron Corporation that still exists today after Enron's failure.
Mm-hmm.
And they had a corporate organizational chart that covered I can't show you here. I got to back up. That covered as far as you could see, but it had so much data on it, it wasn't useful. It treated the change of a corporate name with the same dignity as a merger or asset sale. So we had to go through the chart and take out the stuff that didn't count because they had a very astute and detail-oriented paralegal go through and chart all this stuff since 1877. A lot of it was just noise. And so we had to go and straighten it out. And I was happy when we got all done. We decided that the party that had engaged us had no legal responsibility for the toxicity of the property, which was, of course, we're in the middle of a city now. So that kind of stuff, if the council had not done that at all, I don't know how I could have. Without that chart, I couldn't have functioned. And if you give me the chart, a timeline, um, and give any expert a chart, it's going to be a lot better.
Mm-hmm. And if they don't have the chart ready, and like has there been an occasion where you've asked for a chart and they have expressed their inability to provide one, and then you or somebody from your team had to try and figure out the timeline by yourselves and then maybe prepare a
That's me.
chart?
That's me.
Okay. Okay.
And maybe my crack paralegal, if she's not busy on 10 other things. So she's,
Mm-hmm.
um, but, the answer to that is they will always promise you, it's
Mm-hmm.
like there are jokes in the construction industry. Every question has one of three answers: middle of the
Mm-hmm.
week, end of the week, start of next week. And so there's a lot of construction in Florida.
Mm-hmm.
Every counsel is going to say, yeah, I'm going to get you that. I'm going to get you that timeline. I'm going to get you that timeline. And at some point in time, uh, that's a problem. Uh, it, it, those are, they intend. I, I, I don't mean any disrespect to
Yeah.
all the litigators who failed to fulfill their promises, but it's just time. Time's going to run out. You're going to
Yeah.
have to do this stuff, and you're either going to do it with or without their assistance.
Yeah.
And so I think it doing that controls the depth. If you make one of those things and you
Mm-hmm.
put it in your expert report or your rebuttal report, whatever,
Mm-hmm.
that will help control the tenor
Yeah.
of your deposition.
Yeah. And it will also be a very poor use of the expert's time and very expensive to have the expert do something like the timeline.
Yes, and
Yeah.
that's the way I feel about Savile Row suits as
Mm-hmm.
compared to Hart, Schaffner, and Marks. Hart, Schaffner, and Marks were pretty good suits, but the handmade suit might be better. And
Yeah.
some of this stuff for experts is certainly halfway between Hart, Schaffner, and Marks and
Mm-hmm.
a Savile Row. On the other hand, litigators under the age of 50 don't know what either of those companies are.
Yeah.
Uh, so, uh, yes, it's expensive, and I don't know a way around
Mm-hmm.
it. How else do you master the facts in a complicated case?
Mm-hmm. That's true. So, what is a productive communication and like a productive relationship between an expert and the hiring attorney look like? Like,
It has to be based on respect, which is that you have to respect the litigator's time. The litigator has to believe and act as if what you're doing is valuable. If our hypothetical, just get it for me Tuesday morning, engaging counsel's not somebody you're going to have a long-term relationship. I have one engaging counsel. He and I have worked together so long.
mm-hmm.
In the first engagement we ever worked on, he had one infant, and on the last time we got together for drinks, both of his kids had graduated. He's got that second kid, and they're both out of college. And not the same case, though we did have one case that went a dozen years. Um,
Okay.
but those relationships last. Others, not so much.
Mm-hmm.
And I view it as a kind of respect.
And a lot of times, like we've seen, like attorneys will also have fallouts with plaintiffs or defendants, like the parties they are representing. So, and there may be some conflict, like that can arise between attorneys and experts. So, do you have any tips for addressing areas of potential conflicts respectfully?
Well, yeah, because I'm in a traditional law firm, before I take anything in the door, I run conflicts. And while it's better than AI. It doesn't come back and say you have no conflicts, but
Yeah.
it will trigger matters I have to follow up on. And for example, uh, I've had cases where I've been asked if I'd like to be an expert in a plaintiff's malpractice case against giant law firm.
Mm-hmm.
Okay, when I run conflicts, of course, uh, we do deals with we do cases with giant law firm all the time. So you got to look at how they come out. But you say to yourself, well, uh, I don't want to take a case adverse to them. Our malpractice insurer uh, doesn't prohibit us from taking cases on a malpractice side as an expert.
Mhm.
But barring extraordinary circumstances, I will not take a case against a firm that is insured by our malpractice carrier. And I've turned away a fair number of cases because I don't want to be in that setting. Now, if you're a regular expert and
Yeah.
you don't have a conflicts check, well, you got to be really careful. Because it's not just enough to look at whether or not you were in Smith against Jones, but what if Bob Black was the CEO, who was the bad guy in this case, and now he's another bad guy? I've had the the pleasure to be an expert 3 times in malpractice cases against the guy who keeps failing up.
Mhm.
Each time he got into a better law firm, and then wound up in a deal that hit the rocks, and he wound up getting sued for malpractice. He's out by himself. He may be retired now.
Okay. So let's talk a little about. I'll definitely want to come back to the use of AI, but before we go there, let's talk about the expert report. So, like you said, the first time for the first case, you put up something and it ended up looking like an expert report that you see today. So we have gone through and we talked about Rule 702 and the Daubert standard. Now, Rule 702 has also gotten amended a few times, with the most recent one coming in December 2023, on the 1st of December. So, what changes have you seen in the approach to writing an expert report in light of these amendments, these evolution in the Rule 702?
I don't know.
And yeah,
Okay.
like how is it different from when you started, what it is today, and over the period of time?
Well, I think Daubert may have just been. Daubert was at or about the time I started doing expert witness work on a regular basis, and
Mm-hmm.
it was the cat's pajamas when it was adopted. Everybody said, "Oh, this will change everything," but
Yeah.
but let's back up for a minute. The Rule 702 gives the federal rule, and a lot of the
Yeah.
states are very similar. Some are different, but the
Mm-hmm.
Rule 702 gives the trial judge a gatekeeper function. The trial judge has to decide whether the stuff coming from the expert will assist the trier of fact in deciding its its answer to the questions in the case. And
Yeah.
in my area, special knowledge. Pardon me. Let's back up. Let's make it easy. If you have a quant issue or a science issue, this chemical either does or doesn't turn the water blue,
Mm-hmm.
and so there's going to be an answer there. And they'll other parts of expert testimony, the damages. At least there'll be some assumptions and calculations. You can look at the math. Um, I'm what's called a special knowledge expert, where supposedly because of experience, education, and training, I am able to explain technical issues of the law or practice in a way that will help the fact finder decide.
Yeah.
So the Daubert decision said, okay, judges, there's supposed to be a reasonable basis on which expert Jones arrived at this. Otherwise, you don't let it in. And that's what's called like a Daubert challenge. Okay. And that can be on a variety of things. For example, uh, insufficient testing of something scientific.
Yeah.
Could be a computational error that would disclose things. Um, the in the special knowledge area, those are a little trickier. So you would have expected that Daubert would have put up a lot of blocks right at the door. You're not that
Yeah.
lousy, crummy expert opinion because people who say because I say so.
Yeah.
As
Ipsa Dixit. Yeah.
ipsit dixit which
Yeah.
is Latin for it. You would have expected that there would have been a snowstorm of expert reports didn't get in. Didn't happen. The judges retreated to the well, we'll let it in, and it won't go into admissibility. It'll go into weight.
Yeah.
Just to say, I'm kind of a lazy judge, and I'll let the jury worry about it. And so there was a lot of writing, particularly at the academic level, very critical of this approach. And so it said, now 702 says, it is the burden of the person, the side asserting that expert testimony, to bear the burden of proving it's more likely than not that this stuff will be useful. And so the couple of early cases that came out said, well, if you don't do anything, you've done nothing to carry the burden, you lose, testimony is blocked. When I was with great glee, I went down the hall to my litigation partners and said, see, this will change. No more junk science. And they looked like you, Ashish. They said, nah, you don't know much about judges, do you? And so there have been a couple of cases, and I'm waiting for more cases. And the problem is when you go into this is for you. When you go into Westlaw and research 702, I forget whichever subparagraph it is, you will get and say, I want cases since December 23rd. Last year. You will get 6,000 hits. At least according to my crack paralegal, and she's very good. I said, well, this is not very helpful to me. I'm looking for the smoking gun, and I haven't found it. I expect it will be there. I expect over time judges will be more discerning, and the same kind of people who have a cottage industry of mounting Daubert challenges will mount Rule 702 challenges. But it's not going to change how I write my report. It's the engaging counsel's job to say, well, I'm an advocate for my opinions. I'm not an advocate for whether they're admitted into testimony. So, stay tuned, because like you, I thought it would make a big difference.
There have been a few cases. I mean, we have come across a few cases. There was this Masterod case where the judge had given a previous ruling before the amendment kicked in. And then after the ruling, he wrote he did another Daubert ruling and then applied the stricter standard and ended up excluding a few experts.
Yes.
Then recently, a battery expert was excluded a couple of weeks ago. So if you are interested in Daubert challenges, and it's a shameless plug I'm putting in there, but we have a blog on our website, expertwitnessprofiler.com/blog, where every day we cover at least one. Usually it's more than one case where there has been a ruling on a Daubert challenge. So that is a great way to track. And then every week we send out a newsletter compiling all the cases we have covered to about 2,000 to 3,000 subscribers now.
I need to subscribe.
Yeah, so that will help you stay on top of and any special challenge, like specific challenge. Like recently, an expert was excluded in New York for using AI for calculations, and the AI was not AI. I mean, as you all know, is not great at math. So we keep seeing all different kinds of challenges, but at the same time, the phrase that you used, that this challenge goes to the weight and not the admissibility of the expert testimony, that still is outnumbering the application of the amended Rule 702.
So not that much, meet the new boss.
Yeah.
Same as the old boss. Most same as the old boss. If you were a judge, there would be a seductive attraction to saying, why is it up to me? Let the jurors hear this. And the answer is, if it's junk science, if it's got to do with space lasers, or we didn't land on the moon, or something that is outrageous, you shouldn't give it to the jury.
Yeah.
3 of the jurors may believe that the moon landing was faked.
Or the earth is flat, yeah.
I was going to say for both of our countries, Ashish.
Yeah.
Okay. So So I think that the judges should do their jobs, and which is that they ought to throw some stuff out. And if they shouldn't have, okay, somebody will appeal. But certainly the weight, that's interesting to hear you say, the weight continues to be,
Yeah.
we'll let it in and let for its weight, which is a chicken's, that's running away from both of those. And the Daubert decisions are not a new decision. It's old.
No, it's I think 1993. Yeah.
Yes. Yeah, I said it's old.
Yeah.
Yeah. So it was, and by the way, that's the same thing that they would say is recent. The fact that it's only 40, it's 40 years ago, but it's recent. It's 30 years ago. People, that's
Yeah.
when somebody says that in response to your filing, it means that they don't like the ruling.
Yeah.
And we'll have to see.
hmm
I don't think there's anything left to do other than to try to carefully look at the report and look at whether or not the appropriate sources were cited.
hmm
Most of the time, most of the time there's some wiggle room on citing your sources.
Yeah.
The language says you're supposed to say everything you reviewed, which I think is unhelpful, since what I learned in fourth grade from Mrs. Keeley supports what I do today, but it's
Yeah.
not crucial, although she was a very good teacher.
hmm
So my answer to that is, if I relied on it,
Yeah.
I will footnote it. If I
hmm
think it's pretty important, and I'll list it. But there's a lot of stuff I look at that doesn't get listed
Yeah.
and doesn't get cited,
hmm
and wind up sometimes having to provide additional information
Yeah.
after a decision. But
hmm
I I think that language in the rules is deliberately vague.
Yeah. So let's move on to the need to know your own report inside out. And you have highlighted this earlier. So, how do you prepare for opposing counsel scrutiny during depositions? And because if you know your report inside out, like even if you have not cited something which you may, like you said, you may send a addendum later. But how important it is to like actually know what is in your report, and at what level, in what details should an expert know their own report?
Well, that's a terrific question, because let us assume, for purposes of this answer, which is my practice, I write my own reports. I joke they're my typographical errors. I've done it. Somebody may proof it, but it's I've got my hands on the keyboard. Let's assume that you don't work in some mega outfit where 29 people have their hands on the report.
Yeah.
So let's assume that there is a point in time when you know that report inside out, and
hmm
that's the day before you deliver it. That may happen long before your deposition, and certainly
Yeah.
or still before your trial testimony. And I think that you have to reacquaint yourself
hmm
with your report, which is more than reading it over once or twice. You really need to spend some time with it, or you can wind up having a lot of pregnant pauses
Yeah.
between questions and answers. Um, that said, I've been in some depositions where it's pretty clear that the first time the opposing counsel looked at my report was when they said, "We're now approaching Tampa for landing." And well, I said they're busy guys, and I don't know why that guy was taking my deposition.
hmm
He wasn't very well prepared. And he got better as the day went on, but he, that particular guy wasn't well prepared. So I just think you have to be prepared to reinvest a lot of time, because of the gap between the time when you write the report and when you're going to be deposed, or when you are in trial. And I think that's something that's honored in the breach more than actuality, because again, everyone is concerned about costs. Every Everyone would like every report to cost more
Less.
than end dollars. And I can't do anything about that.
So, what advice would you have for somebody who wants to become a security laws expert like you, like transactional attorney, couple of years in, want to do expert witness work? How can they get started? What are the one or two things that they can do to get started?
Well, I'm not. Let's assume you're more than a. I think it's a bad idea to attempt to present yourself as an expert. I
Yeah.
remember when I started, I got an interview with a distinguished plaintiff's lawyer, and he looked at me, and he was a few older than me. And he looked at me and he said, "I'm not sure you have enough gray hair to be my expert." Now I have enough gray hair. It's just that I don't have enough hair. So, but and so I think it's not a job for somebody who lacks sufficient experience in the endeavor to command respect. But if you are past that hurdle, then I think the thing you should be doing is talking to if you're in a law firm, talk to your partners. If you're in associations, or then you should let yourself be known. You should obviously, this is not me because I'm kind of an old fogey, but you should post to social media. You should articles. You should see if you can get speaking opportunities like this one, where you say, I wasn't tongue-tied. I didn't use any bad language. I didn't miscite any cases, what all those are all good things. Uh, and and I guess the you should be a kind of person who can think on their feet. If you're the kind of person that needs to think about stuff, then maybe expert. One of my partners is a spectacular transactions lawyer, and he hates being deposed, and he gets asked. He's very distinguished, well known nationally. He gets asked to be an expert all the time. I get all his leftovers. He does not want to do this because he doesn't like I guess the pressure. But some people, as that famous trial lawyer Billie Jean King said, pressure is a privilege. And she's right. And I'm no sports champion, but she's right about that. And so,
Mhm. And you're also a member of the Securities Experts Roundtable, the SER. And can you talk a little about what are the advantages for experts to join a network like that um, within their discipline? And because we see a lot of experts networking with experts from outside their discipline, hoping that they'll get referrals from experts who are experts in other fields, but the SER will, again, primarily securities experts. So what advantages do you feel are there for somebody to join an organization like the SER?
SER, excuse me,
Yeah.
is is unusual because it's not
Mhm.
it's not a defendant's. It is a collection of securities experts who enjoy each other's company and share information in an attempt to improve their activities. We're not like a matching service.
Mhm.
We're not going to go get you um, engagements. So I found it like the American Bar Association that I've been
Mhm.
active for a long time. You you spend time with people who are in the same part of the swimming pool as you,
Yeah.
and you enjoy their company, and they share information with you, and you share information with them. And at the end of the day, you probably are more equipped to do your job well than you were before.
Mhm.
And that's oh, I just heard the first dog bark. Ashish.
That's perfect.
That's-
That's perfectly fine. We'll take.
that'll end the interview sooner.
No,
We haven't had any dogs come in yet.
mine is upstairs in like with my wife, and she's keeping her quiet because if there's somebody at the gate, she is like she's a barker. Yeah, she's a barker. Yeah.
So anyone who comes to, we live on a cul-de-sac, and anybody that comes down the cul-de-sac, and we've had a lot of that since the hurricane, they are barking up a storm. So
Yeah.
that hasn't happened yet. Well, this is great. They nap after breakfast.
Uh-huh. So, Richard, this has been great. This has actually been like more than everything I hoped that this interview would be. I definitely had a great time, and I got a lot, got a lot to learn. Is there anything that you would want to add before we wrap up this interview?
Well, the only thing I'd like is that across the country,
Mhm.
experts and engaging counsel persevere their relationship with respect, and that when you engaging counsel,
Yeah.
say you're going to engage them early, and engage them in a substantive way, so that you don't say, "Oh, here are 400,000 pages of discovery. Now you have everything." Well, that's not so helpful. And so to take enough time to build the relationship in a way that will be best for you and your clients. And that's, I have to say to the expert, you can't, you need to do what the SER says. The SER seal says, seek and speak the truth. That your only client as an expert is the truth, or your opinions.
Mhm.
You're not a defense witness. You may be called by the defense, but you're not a defender. So those are the two pieces of information. And
Mhm.
you as an expert, you will be on the stand. Opposing counsel, we ask you a question, and you have to say sometimes, "I agree with you. You're right."
Mhm.
And even if you think your opinion is still right, the guy or person on the other side is entitled to be respected too.
Yeah.
So that's it.
That's great. That's really great advice. So, if somebody wants to reach out to you, what's the best way to contact you?
Oh, I should make you my agent, Ashish. Uh,
I love to do that.
our Leisner, just as you see there, at
Mhm.
Trenum, TRENAM law, and we're on the web. And I like the picture that they have of me on the firm's website.
Mhm.
I have more hair in that picture.
We'll use that for the thumbnail of the podcast of this episode.
Well, thank you very much. I appreciate you.
Thank you so much, Richard. Have a great one.
Take care.
Lovely talking to you. Bye bye. Take care. If you found this podcast useful, remember to subscribe and give us a review on Spotify, Apple Podcast, YouTube, or wherever you listen to podcasts. This will help other users find this podcast and benefit from the insights shared by our guests. If you'd like to be featured as a guest on this show, please write to media@xlightum.com. See you in the next episode.